right, welcome everybody. I know we'll still have some people jumping on. That always happens. So let me just start a little slowly. I'm Liz. I'm your host for Lunch with Liz today. Thanks everybody for taking the time to join us this afternoon for our topic, which is estate planning for our community. Um, I host these every month. Well, most every month. We take July off typically. Usually different topics of interest to, well, to me anyway, right? A bunch of legal mumbo jumbo, right? But what I like to do is have these types of Zooms so that people have a chance to ask questions and get clarification versus, potentially doing a blog or doing a podcast where we can't have that conversation. The main thing I want to make sure of is that you've spent the time today to come join me. You must have something you want to know. So I want to make sure that before you leave today, you know that whatever that nugget is that you came on to learn, and that hopefully I've dispelled some myths out there concerning estate planning, whether it is for people in the LGBTQ community or people in other communities. A lot of these topics really are broad and they apply to everyone. But today we are going to focus on the nuances of our community. So how's it going to work today? I have some slides. You can see those up. We're going to talk through those. Usually it takes me about 20 minutes or so just to run through the slides. I do the slides because I know some people are visual learners versus audio learners. So I like to have both me talking and the slides up there to help bring points home and make things clear for you. Please feel free to ask questions. You can do that a couple different ways. You can come off mute and you can come talk to me that way. You don't have to turn on your camera if you don't want to. There's also a chat function. You'll see that for those of you who were signed on when I did it, I posted in the chat about noon saying that we would start in just a couple of minutes. Feel free to use that. I'll check it periodically as I'm doing these slides. And then when the slides are done, I'll shut the screen sharing off. And at that point, we can have a conversation, whether that's via you putting something in the chat and me talking out loud about it, or you coming off the mute and us having a conversation. Keep in mind that if you have a real specific question, you're going to get the "it depends" answer, and I'm going to suggest that you talk to a lawyer, whether it's me or someone else. So don't give away too many details that would impact your attorney-client privilege with somebody. That being said, let's give it a start this afternoon. Next slide. All right. So today's agenda is all from the LGBTQ plus perspective. These are documents that are critical really for anyone. But today we're going to talk about it under the eye of our community. And that's because we have some different needs, right? We have the need to, unfortunately, the need to think about potential legal and social challenges to our relationships and our family structures, right? So we need to plan and prepare for that. We also have a lot of unmarried couples, unmarried partnerships in our community. And this significantly impacts how assets get distributed, how you can interact in a hospital or a doctor's office, how you can make end of life care decisions for each other, how you can make financial decisions, custody of children, those types of things. So when we are looking at it from the lens of the LGBTQ community, it is because of those different dynamics. So what we're going to be talking about today is really two things. I like to divide it into two things. One is planning for incapacity. So what happens if we can't make decisions for ourselves? We're still alive, but we can't make decisions for ourselves. And then planning for death. And we're going to talk about things like probate, Should you avoid probate? How can you avoid probate? And then, like I said, we're going to open it up for questions. Um, if we zig, I want to zig with you. So if we go off on something different, because that's how the conversation goes, I'm fine with that. I just want us to stick with really the estate planning part of it today. Sometimes I'll get specific questions about a different topic that I do a lunch with Liz on. And if we do that, I might ask my right hand, Vicky, who's on the call here, to post an older lunch with Liz that would give you some more detailed information about that. All right, moving on. All right, so I talked to you about how I divided into two categories, right? The one is we are alive but can't make decisions for ourselves. The other is planning for death. So the top two check marks on this slide are incapacity planning, and we're going to talk about those, each of those documents. And then the last part is planning for death, whether you decide to go with a will-based plan or a trust plan or potential other options that we'll briefly talk about that you can implement even on your own to try to avoid probate. So I know at this point you're sounding like this sounds like a lot. So what if I just bury my head in the sand? Like what could go wrong, right? Well, I would like to say that not having a plan, and that slide has a typo on it. So not having a plan is a plan. It's just not a very good one, because it's only when you have a plan, a properly written plan, that you have a say. Because if you don't have that properly written plan, you have a probate judge that is going to be involved, that will implement the plan that the state of Florida has for you. And you will not have control over your assets. You will not have control in the case of incapacity, you won't have control over your body or assets. And then oftentimes your biological family would be the default that the court would put in charge. And sometimes that's not who you would want to be in charge for a myriad of reasons. So I probably should get this tattooed on me. I don't have any tattoos, but this might be one, that not having a plan is a plan. It's just not a very good one. So why is planning so critical? Well, it's critical for us, like I said at the beginning, because we do have these legal and social challenges with our relationships, and we never know when those are going to rear their ugly heads, right? So we have to be prepared for those. Having a plan is the only way that you have your say, that you can choose your decision makers, that you can choose your beneficiaries. Otherwise, the law is going to have a decision maker and a beneficiary in place for you that the vast majority of the time is not the decision maker or the beneficiary that you would have chosen. And you're going to see the word chosen written a lot in capital letters, and me emphasizing that, because that is why planning is so critical, is because you get to make the choice versus somebody else making it for you. Additionally, planning is critical because if you do go through the probate process, and we're going to talk about what probate is in a few slides, but if you do go through the probate process, your assets will be lost to the probate process, at least to a certain extent. Lawyers have to get paid, the court has to get paid, creditors have to get paid. So avoiding probate, if possible, is really the smartest way to go about transferring your assets. Also, what planning does is it puts the person in charge that you want to be in charge. Otherwise, you could have conflict between people who think that they should be in charge. This can happen a lot with second marriages and children from first marriages. It can happen a lot between partners whose families don't approve of the relationship. So having these things crystal clear in writing, properly written, properly executed, and by that I mean witnessed, notarized if it's required, to ensure that it's very clear that you have chosen this person and you have chosen this method of distributing your assets, and there's no way that it can be contested. All right, moving on. So let's talk now about the documents. And you remember on one of the first slides, I said I divided it into two categories. And the first category being, hey, what happens if I'm alive, but I don't have capacity to make decisions for myself? So for this, we're talking about two different documents. The first document being the durable power of attorney for finance. I consider this the most important document, and I'll talk a little bit more about why in a little bit. But this is the document that lets somebody, your chosen person, step into your shoes. They can pay your bills, sell your house if they need to, potentially run your business, conduct payroll, that sort of thing, if they have to do it. And the reason why it's the most important document is because without it, and you become incapacitated, your loved ones will be forced to go to court and get a guardianship. And I'll talk more about guardianship and why you want to avoid that in a couple slides. But just imagine for a second. I think we've all seen it, right? With loved ones, whether they're related to us or friends potentially. Somebody has a stroke out of the blue. Somebody gets into a car accident. Somebody then has Alzheimer's, but they hadn't really paid attention to it till it was too late. And now you're in this position where how do your bills get paid? How do we access funds to pay for health insurance or car insurance or house insurance or doing your taxes? Who has access to your home? Who can feed and care for your pets? This person that you give this power to can do all of those things. The last bullet there says choose your agent carefully. Absolutely choose this agent carefully because they step into your shoes. Have I seen people misuse a power of attorney? Absolutely. There are civil and criminal penalties for misusing a power of attorney, but sometimes that doesn't really help if all the money's already gone. So you want to choose that person carefully. Should be someone that conducts their own affairs in the proper manner, knows how to balance a checkbook, pays their bills timely, those types of things. Because if they can't do it for themselves, they're certainly not going to do it for you. The reason that it's called a durable power of attorney is because it stays in effect even if you become incapacitated. There's a lot of different types of powers of attorney out there. Sometimes we do it for one specific thing, like you have a soldier who's overseas and her husband needs to close on the house. She can give him a limited power of attorney to do that one thing. The general durable power of attorney, though, is broad-based and it stays in effect even when you become incapacitated. One thing I want to say before I move on from this slide is I get some clients that come in and they want what we call a springing power of attorney, meaning that it only takes effect if the person becomes incapacitated. Florida doesn't do those powers of attorney anymore. Every durable power of attorney that we do is in effect immediately, which again, why that last bullet is so important is because you want to choose your agent very carefully because they do have that authority as soon as you sign the document. All right, the next document that is important for incapacity planning is your advance directives. And my personal practice is to combine these into one document. Some attorneys do divide them into separate documents, but for our planning purposes, we're just going to call them advance directives. And they include a living will portion and a healthcare surrogate designation portion. The living will portion is what you can do to make some of your wishes known. Do you want life-sustaining measures withheld if two doctors have determined that there's no medical probability of you recovering? Do you have wishes when it comes to dementia or Alzheimer's about care and facilities and food and water and that type of thing? That's what a living will can do. It can make some of these decisions ahead of time, which is very important if you have a strong feeling about it one way or the other, because this is the only way that you're going to be able to articulate this to your surrogate if you haven't already had the conversation with them. I recommend to my clients that they have these conversations, even though they're awkward and uncomfortable, so that their surrogate knows what their wishes are, but it's still good to have it in writing so that if there's disagreement between your partner who's your surrogate and your family who's not, that it's clear in writing what you wanted to have happen. The next thing the advance directive does is it designates that person to make the decision. And you can do co-people in this. I never like co. I recommend against it. But you can do a co-surrogate here, but to make the decisions. But ultimately, one person is going to have to do it. So I like to have just one person who's in charge. When I say choose your agent carefully on this one, it is not everyone's meant to be an advocate. And when you think about being a healthcare surrogate, it actually very rarely is making the decision about pulling the plug or ending care, right? The vast majority of a healthcare surrogate's job is just to advocate for pain pills, to advocate for a different therapy, to advocate for the doctor to actually show up during his morning rounds. So not everyone's built for that. And some people are way better at it than others. And that's why I say to choose your agent carefully. Another thing that I do for my clients too is if there's someone you specifically don't want to be your agent or to have any say so in your healthcare, we make sure that we indicate that in the healthcare surrogate designation as well. All right, so we've talked about these two documents, the durable power of attorney for finances, which is letting someone step into your shoes to pay your bills and coordinate payment of taxes and that sort of thing. And then the healthcare surrogate living will, which focuses on your medical issues. Without these documents, then your family, your friends, your loved ones will have to set up a guardianship. And what a guardianship is, it's a legal proceeding where you go to court and a judge appoints someone to be your guardian. Can be guardian of the person, making your personal choices about where you live and that sort of thing. It can be a guardian of your finances, or they can be two different people who serve those roles. Once a guardianship is established, then the court is involved with everything that happens with you, with your money, with where you live. Everything has to be approved by the court. When money gets spent, it has to be approved by the court. If you change, your family wants to change where you live, that has to be approved by the court. You might also have a stranger being in charge. And I have seen this happen too many times where someone just didn't have these documents in place, put their head in the sand, thought that there was always time to do it, but then comes that stroke, then comes that car accident, and now it's too late. Because once you're incapacitated, we can't do the power of attorney. And then we have to go the guardianship route. So when I said at the first couple of slides that I think the power of attorney is the most important document, it's because of that, because the repercussions of not having it and then needing it are so significant, both cost-wise and the invasiveness of the proceeding. So that's my soapbox about powers of attorney. All right, so now we're going to switch gears and we're going to talk about death planning. So we've talked about incapacity planning. So what happens if we are alive but we can't make decisions for ourselves? And now we're going to pivot to planning for death. And when I was a younger lawyer, I used to say, well, if you die, and now that I got a few, or maybe more than a few gray hairs, I say when we die, because we're all in line, right? We just don't know what our number is in line. So planning for death is the biggest gift that you can give to your loved ones, so that you can make the process as easy as possible. So when we're talking about death planning, I think it's important to have an understanding of what probate is first before we talk about a will or a trust or anything like that, so that you have a good basis of knowledge about whether you think avoiding probate is important for you or not. Some of my clients, it's very important, and some don't care. But what probate is if someone dies and they have assets in their name versus a trust's name, and it's in their name alone versus a joint owner, there has to be some way to transfer that ownership to somebody else. So let's say I died and I had a bank account that was just Liz Moneymaker, and I had a house that just belonged to Liz Moneymaker, no co-owners, no nothing. There has to be a way for that to transfer to either where my will said it got transferred to, or if I didn't have a will, what Florida law says it gets transferred to. So that's really the simplistic way to describe probate. It's just the way the law transfers ownership of an asset. You see that last bullet point there, and I'm going to talk about that as we go through the slides because it is kind of confusing. But if you rely on a will to transfer assets, the will has to be probated. A will does not avoid probate. Can you have a will and still avoid probate? Yes. But if you're relying on the will to transfer the asset, it will have to be probated. And I'll talk about that a little bit more because I know it can get a little confusing to people. What probate involves, again, it's a court, a judge, and it's based on county. So Pinellas County has their own probate court. Manatee County has its own probate court. Every county in the state of Florida has its own probate court. When somebody dies with assets just in their name and they didn't have a beneficiary attached or a joint owner attached or some other mechanism to transfer that asset, then we're going to court for a judge to oversee the legal transfer. So that judge will decide, is the will valid? Was it signed appropriately, notarized appropriately? Did it follow Florida law? If you don't have a will, Florida has a statute that says who gets your stuff. So real easy, I will tell you that if you're married, typically your spouse will get your stuff. If you're not married, your parents or your children, depending on different things. But bottom line is it's not going to go to who you've chosen if you don't actually just want your next of kin getting your assets. One thing that is something that bites some people in the derriere is if, let's say I own a house and I have adult children from another relationship and I don't have a will in place, right? And I pass, then my spouse only gets a life estate in my house, but the remainder interest goes to my children from a different relationship. I don't want to get too in the weeds about that, but that this is another reason why, especially if you are in a relationship and you have children from a different relationship, you want to make sure that you have a plan in writing in place. So typically in Pinellas, anywhere in the Bay Area here, I would say a routine probate is anywhere from 6 to 12 months. It can be longer than that if there's more assets, if we have to sell a business, if there's multiple real estate or significant other legal issues, potentially arguing beneficiaries or something like that. But for a simple routine probate, you're looking at 6 to 12 months. Some people don't care about that. Let's say I have some clients that they don't have family they're giving anything to, they're giving it to charity. And so they just said, you know what, the charities can do the probate. I don't care. They're getting this money for free. They can handle all that. So sometimes there's reasons why we don't care to avoid probate. All right, next slide. So let's see. Did I skip a slide? I might have skipped a slide. Yeah, sorry, I skipped this one. So we did a full hour last month on Lunch with Liz about what is Florida probate and how to avoid it. So if you want a more in-depth Lunch with Liz about that, that's on my website. And sorry, Vicki, I didn't give you the heads up about that, but if you can put that in the chat for anybody that might want that, that would be great. And I think maybe I did get a little ahead of myself, but I think I hit all the stuff on the slide anyway. All right, so now we're going to go to the documents. So for incapacity planning, we talked about the power of attorney and the living will, the healthcare surrogate. Now we're going to talk about the documents we discuss when we are talking about planning for death. So the first one is your last will and testament. For your will, it essentially tells people what you want to have happen to your assets at death. And it only takes effect at death. It can also name guardians for minors. It can name caretakers for pets. It names your personal representative, which is also called an executor, but in Florida we call it a personal representative. It's where you list your beneficiaries. And highlighted at the bottom, if you are using the will to transfer your assets at death, it will have to go through probate. So if you have friends or family out there and they say, oh, I made a will, so I won't go through probate, you can say, well, here's a link to Lunch with Liz, because if you are relying on a will to transfer your assets, it will have to go through the probate process. When I'm doing an estate plan for someone and we are trying to avoid probate, we still do a will. We have to do that, well, for, because it's the best legal practice to do for a couple reasons. One is it names your personal representative, and that's the only person after you die that would have authority to deal with the IRS, to deal with Social Security, to deal with any post-death actions. Maybe you died because someone was negligent. That executor, that personal representative, is the person that can sue on your behalf. The will also, if you have minor children, dictates who would get the minor children. Same thing with pets. So there's still reasons to do the will, like what happens to your personal property, even if we're doing a probate avoidance plan. So I want you to know that, so you don't just say, well, I can figure out how to avoid probate. I don't even need a will. I still highly recommend that you have a will in place to cover these other things. All right. Next document, we talked about the will, is a revocable trust. Some people call it a living trust. Some people call it a revocable trust. What those two words mean, living, revocable, it means that the document is amendable. It's changeable. You might have heard an irrevocable trust. Well, that's different. That is typically an unchangeable trust. But we like to use revocable trusts in estate planning to avoid probate if you need the trust to avoid probate. I like to think of a trust like a bucket. So instead of Liz Moneymaker owning my condo, I create a bucket, and it's Liz Moneymaker's trust. And I retitle the condo into the bucket. Why do I want to do that? Well, because the bucket doesn't die when I die. So therefore, we avoid probate that way. So if I put my condo in the bucket, I put my investment portfolio in the bucket, then when I die, my trust says what happens to all of that. And I put someone in charge that distributes it, and it's outside of the court process. That is why you hear people say, oh, you need a trust. You need a trust, because a trust is a great tool to avoid probate. Is it the panacea, the savior of all things? Absolutely not. What I find too often is people create a trust. They either go to a lawyer to create a trust, they go online to create a trust, and now they have this 50-page pretty document in a binder, but they never go and actually retitle assets. So unless you retitle assets, you have an empty bucket. And let me give you an example. I have a probate going on right now where the lady who passed away had a trust. She created it years ago in Illinois. She had some assets titled in the trust, but she also had multiple bank accounts, multiple other assets, including her condo, just titled in her name. So she had a bucket that had a little bit in it, but the bulk of her assets were not in the trust. So now we have to probate those assets that are outside of the trust and put them into the bucket, and then take them out of the bucket to follow her wishes in the trust. So we're doing double work. It's costing the double money, and it's not what she intended because she didn't fund the trust appropriately. When people come to me and because their best friend or their neighbor or their mom or somebody have a trust and they come and they say, I need a trust, we walk through the pros and cons of having a trust. My thing is, and I have it highlighted on the slide, is what's the least complicated, least expensive way to accomplish the goal? Sometimes it's a trust and there's no way around it, but a lot of times it's not. A lot of times we can go with a simpler, less complicated plan and still avoid probate. And we're going to talk about some of that in a couple slides. The thing about what works best for you is all case by case dependent. It's going to depend on all of these bullet points and then 100 more. But if you have anything belonging in any of these bullet points, then we may be talking about a more complex plan, a trust-based plan to accomplish your goals. Sometimes not, but oftentimes these are the complexities that are going to require a trust-based plan. All right. All right, so, all right, Liz, what can I do? What can I do myself to try to help avoid this probate? Because it sounds terrible. That's what this slide is about. It's some things that we can do outside of a trust to avoid probate. I'm going to skip joint ownership and I'm going to hit that last. So the second bullet there is pay on death designations. This is what you can do for your bank accounts, your checking and your savings, your money market. You can go to the bank, fill out a form, and when you die, those funds will be paid over to whoever you've indicated on your pay on death form. I will tell you that this is probably the vast majority of issues that I see when people come to me for a probate. They might have had their IRA or 401k and with beneficiaries. They jointly owned their house potentially with somebody else, but they had these checking and savings accounts with just their name on it. And sometimes maybe there's only 1,000 or a couple thousand in there, and it's going to cost more money in probate than it is to get that money. So it's going to cost 3,000 for probate, but there's only 2,000 in the account. So they just tend to walk away from that money. That's why I want to reiterate, putting a pay on death designation is one of the easiest ways you can avoid probate with these bank accounts. Is it a kind of a pain in the butt? It is, because a lot of these banks make you go in to do it. They don't have an online option, but it's well worth it, and something I harass my clients to do. Similarly, you have the transfer on death designations. These are the same thing as pay on death designations. It's just a different name for things like brokerage accounts and CDs. But on both of those, you can put beneficiaries on those accounts so that they transfer at your death. Next bullet there is beneficiary designations. And essentially, it's semantics, right? Pay on death, transfer on death, beneficiary designation. The end result is the same. It is going to somebody else at your death without having to go through the probate process. But beneficiary designations are typically on your retirement accounts, on life insurance, on annuities, those types of assets. So you can avoid probate with those things. The last bullet, and I'm going to go back up to the first one here in a second, but the last bullet is what we can do for real estate in Florida. So if you own a condo, if you own a house, and you want to leave it to a person or a couple of people, we can do a ladybird deed. And essentially what a ladybird deed does is it puts a beneficiary on the deed. You can change your mind, you can take that beneficiary off, you can still sell your house, you can refinance your house. It is completely yours. The person's name on the deed, they have no current interest in your property. It's only at your death that they receive it. There are pros and cons. There's drawbacks to a ladybird deed, so I make sure that I talk to my clients about all those before they make those determinations. I would say for all of these that we've talked about, the biggest drawback is there's less ability to contingency plan with these beneficiary designations, and you really have to keep on top of your designations in case you need to make changes. Whereas if we do it via will or trust, we can layer in a bunch of contingencies in that, um, to make it easier so you don't have to come back and update your document very often. All right, so now I'm going to go back up to the top. So joint ownership, and I wanted to save this for last because you got to be really careful about joint ownership. If you're married, that's one thing. It's much easier, much simpler taxation wise and all of that. But keep in mind that if you put someone on your account because it's convenient, because you want to make sure that they get it when you die, that's their account too now. They can take the money legally. If they get sued, that money would be considered theirs. If they declare bankruptcy, that money would be considered theirs. So you want to be very, very careful about who you might put on as a co-owner of a bank account or investment account or something like that. There's also gift ramifications if you're adding someone on, and that can have a serious consequence to capital gains taxes when it comes to real estate. So I just put that big red flag there to say, hey, can this be a tool? It absolutely can, but you want to make sure, that you're talking with your CPA, you're talking with your lawyer about the impacts down the line if you do that. Right? I know there's some questions, and I will get to those, I promise. I just have a couple of examples. So this is a non-trust probate example. So John owns a house. He has a checking and savings account, a brokerage account. He has some retirement accounts and life insurance. So assuming he doesn't fit any of those bullet points we talked about a few slides ago, right? No blended family, no, special needs beneficiaries, no out of state real estate, anything like that. Maybe we can come up with a simple plan for John. We do a ladybird deed for the house. We put pay on death designations on his checking and savings. He does transfer on death for his brokerage, and he makes sure that his beneficiary designations for retirement and life insurance are up to date. That would avoid probate for John. Okay. And that is a very common plan that we put in place for our clients. All right, I'm going to stop sharing now, and I'm going to go to the questions. Karen says, how do you transfer possessions without the will and probate? I'm not sure I understand that. Are you talking about like personal property possessions? If there's no will, then the personal property would go to whoever's in line in the Florida statute. So whether that's a spouse, children, parents, siblings. If you want to give me some clarification on that, I'll come back to you on that,
Sure.
Karen.
Should I type them or
Yeah,
use audio?
no, go ahead. Just tell me.
Okay. I was just thinking about, furniture and, stuff that doesn't have a name on it.
Mhm.
Something that's not titled. If you have any will, do, do you end up in probate, or how do you, you know?
Typically not. Typically, unless you are, hiding the Mona Lisa in your house, that
Oh, I
typically
am.
are, yeah, typically our personal property, our clothes, our furnishings, stuff like that, is not really that much. It may be a lot to replace, but the current value of it is not that much. So it's typically exempt from probate. So we're typically not worrying about that. Um, but in the will, we would specifically say where that tangible personal property would go.
What
And
what
sometimes
triggers that you have to um file the will, and what triggers probate then? I mean, do you have to just be honest and say, we've got a will here, and what are the um
well,
y-
there
if you've got
wouldn't be
everything.
there wouldn't be probate for the exempt personal property. So you wouldn't have to worry about that.
So if the will only talked about exempt personal property, you don't have to file it, or
But you file the will, but you don't have to
okay.
there's a difference between filing the will and probating the property.
Oh, okay.
Yeah. But
Alrighty.
typically speaking, we don't need to use the court process to transfer the ownership of a couch or a
Sure.
vase or dishes or anything like that.
I just didn't know if it would trigger you know, a
No,
flurry of things that you'd have to do just because you wanted your furniture to go to somebody.
no, typically not.
And does a will become public information
Yes.
no matter what?
Once it gets filed, it's public record. Yes. That's one of the reasons why people go with the trust sometimes if they want things to be private.
Okay,
Yeah.
good.
All right. All right, Kelly, does changing your home to a trust affect your homestead exemption? Not if you do it right. So there's phraseology that we put in the deed, and there's phraseology we put in the trust to ensure that you preserve that homestead exemption and your constitutional probate rights. All right, Kirsten, if I do a ladybird deed and leave my house to my two adult children, is there a way to say that my partner has 1 year to find a new place to move to? Not via a ladybird deed, and that is one of the drawbacks. So once that becomes your children's property, they're now the landlords. Now, you could potentially enter into a lease, but I don't want to get into specifics about that. But you you know I think there would be some concerns about, do your kids get along with your partner, and that would be something I would want to explore with you. But you'd want to have it pretty laid out in some sort of legal documentation. If partner is going to stay there for a year, is partner required to pay rent, utilities, insurance, taxes, that kind of thing. So that would be something you would want to have in writing ahead of time. Because
Okay.
once your children inherit it, now they're responsible for all of that. So if you're going to prevent them from selling it or moving in or whatever, you'd want to have something in place like that. That's typically where we would use a trust-based plan to give someone to have a right of occupancy for a period of time. Um, yeah, that is one of the limitations to the ladybird deed for sure. Um, I have a trust from Texas. Can you help adjust to fit Florida law? Will a ladybird deed be enough? I wouldn't know if a ladybird deed is enough because I don't know your whole situation. Um, if you have a trust from Texas, how do I say this? So just because you have a trust from another state doesn't mean you need to change it because you moved to Florida, unless there's some other reason to change it. I administer trusts all the time that were written somewhere else. Um, I do provide a document review for clients and kind of give them my opinion about what things I could do for you in Florida. But if you wanted a Florida trust, we would restate that Texas trust. Because I'm not licensed in Texas, I wouldn't amend a trust that was written in Texas. So should you restate your trust to Florida? I don't know the answer to that, but you don't need to do it just because you moved, if that makes sense. All right, so I've come to the end of the written questions. If you have any other questions, you can either throw them in the chat or you can just come off mute and we can have our own chat. While I'm waiting for questions, I will say that what we do run up against in our community a lot, it's unfortunate, is clients that don't have anyone that they trust to name as their fiduciary. They don't know who they can name as their power of attorney or their healthcare surrogate or their personal representative. And for that, I do have excellent referrals of people that do that for a living. And I know that seems like, ooh, I don't know that I want someone I don't even know to make those decisions for me. But honestly, oftentimes it's the best way to go because now you have this independent person. They have no ties to family, they have no ties to friends, and they're specifically there only to follow your instructions. These are called professional fiduciaries. We actually have one on the call right now, Kathleen Seedy, one I highly recommend. But just know that. Don't let that be a reason you're not doing your plan. If you're just like, I don't even know who I would appoint, just know that there are some other options out there for sure. One thing I didn't mention in the last will and testament is that Florida does require that your executor, your personal representative, either be related to you or be a resident of Florida. So if you want to name your best friend Bob, who lives in Georgia, you can't do that in Florida. Some other states don't have that requirement, but Florida does. All right, let's see. Next question. Being a married couple, everything does automatically go to surviving spouse, doesn't it, if we haven't done a trust yet? No, things do not automatically go to your spouse just because you're married. If you are joint owners of the house, of the bank accounts, yes. But if your spouse has their own bank account and you're not listed as a joint owner or a beneficiary, you'll have to probate that asset to transfer to you. If you're on the deeds together, but it doesn't say that you're a married couple or it doesn't say that you own it jointly with rights of survivorship, you'll have to probate the half of the asset that was owned by your spouse. So that's a great question because the answer is unequivocally no. Same thing on the power of attorney. Just because you are married to someone does not mean that you can make financial decisions for them contractually unless you have that power of attorney. Great question, Kelly. Thank you for bringing that one up. I need to make a note to always talk about that in the future. Okay. If you pass away with debt like student loans, would they go after the assets that you're leaving to your spouse? So, student loans are very demanding. They don't go away very easily. But here's the thing. There has to be a mechanism by which to get money from your estate, right? So if your money is beneficiary based and it's going to your spouse or joint owned by your spouse, and there's no probate estate for the creditor to make a claim against, there's no way for them to get the money. Your spouse is not required to pay the debt unless they're a co-signer, right? That's different. Then that's their debt as well. But oftentimes I have very relieved spouses come to me. I can think of one just not so long ago whose husband had a long battle with cancer. And the husband finally passed, and the client came in with all these medical bills for the husband. And he was relieved to know that he personally was not responsible for those. His husband's estate was, but not him personally. Um, so typically, unless you have an estate opened up and there's estate assets, then no, those debts would just not get paid. And your spouse, again, would not be liable for them unless they are a co-signer. Okay. Karen, does the durable power of attorney end when you die? It certainly does. At death, that's when that personal representative executor role comes into play. The power of attorney dies with you. Does having house, vehicles, etc. titled with or versus and transfer them allow sale without probate? Yes. Yeah, typically one vehicle is exempt from probate anyway. So I just always like to say in the will where that tangible property is going. So, if it is just owned by one spouse, for example, then I say all the spouse has to do is go to the DMV. I mean, nobody wants to go to the DMV, but typically that's all the spouse has to do is come to the DMV with the will, and then they sign an affidavit down there, and they can transfer the asset. But if you have more than one car, then you will be probating it unless you have other ways to transfer the asset. Okay. While we're waiting for any other questions, we're taking a break next month, so no lunch with Liz. I will literally be going fishing. Then in August, we're back with a special guest, Christina Faher, who's a family law attorney. And we're going to be talking about estate planning and divorce and how that all impacts your planning. Um, all right, it's about 10 till. I am done with my programming. If you have other questions, I'm going to stay on. But if you have gotten your fill, you are free to go. Hope to see you at another Lunch with Liz soon, hopefully in August, or we've got some great stuff lined up in the fall as well for Lunch with Liz.